Hello, I'm Brian Lucareli, Director of our Private Client Services Group and co-chair of our Family Offices team at Foley and Lardner. And today I'm here with Jim Lundy, partner and member of our Securities Enforcement and Litigation practice, and Katie Keating, an associate and member of our estate planning practice. Welcome to you both for joining us today.
Hi, Brian.
Thank you.
And today we're going to discuss the most recent case of Donoghue versus Smith, which is a securities law case, but involves a popular estate planning strategy called a Grat. So this is the first time we're doing two people on this, so I'm excited about this. The first time we're talking about a case. But before we get started, can I ask each of you just to spend a moment and share a little bit of your professional background before we get started?
Sure. I'll go first. So I'm an associate in the Estates and Trust Group. I work with high net worth individuals and families to design estate plans that are designed to transfer wealth from one generation to the next in the most tax efficient manner. And in connection with this, I often advise on business succession planning and charitable planning as well.
Great.
Thanks, Katie. Thanks, Brian. So my practice is in securities enforcement and litigation, where I'm a partner in that practice group. I work with firms through enforcement investigations and through securities litigation. Prior to joining private practice, I did spend almost 12 years working at the U.S. Securities and Exchange Commission, and for about a decade of that time working for the Division of Enforcement.
Well, great. I clearly have two experts today. And so, Katie, let's start with you. So can you explain to us from a very high level what a GRAT is? I know it's an acronym, but you're going to educate us.
Yes. So the term GRAT is actually an acronym for Grantor Retained Annuity Trust. And a GRAT is a special type of trust, like Brian mentioned, that has become a very popular estate planning strategy over the years. It's actually allowed under the Internal Revenue Code and has just taken off. But the way a GRAT works is the grantor, which is the name we give the trust creator, would transfer assets that he or she expects to appreciate in value to a trust for a term of years. And during this term of years, the grantor would retain an annuity interest and would receive annuity payments from the trust. Now, these annuity payments would be calculated using the IRS 7520 rate in effect at the time the trust is funded, and would generally equal the amount of the initial transfer to the trust. So at the end of the trust term, if the grantor is living, and to the extent there are any assets remaining in the trust, which would be any appreciation in excess of that 7520 rate, those assets would pass to the beneficiaries named in the trust agreement free of gift and estate tax. So that is a very broad overview of the estate planning strategy, but hopefully that provides a little context because, as you'll hear more from Jim in a minute, the stock at issue in this case was originally held in a few Grat trusts.
Okay, great. Thanks for the explanation. And so, Jim, we're going to flip over to you real quick. And so what can you give us a brief overview on Donoghue versus the Smith case and the short swing trading?
Sure, happy to do so. So Donoghue versus Smith is a shareholder derivative action in which the shareholders of the Sinclair Broadcast Corporation filed suit and sought disgorgement of approximately $5.5 million in alleged short swing profits realized by an individual named David Smith. Mr. Smith was a corporate insider, director, and beneficial owner of more than 10% of the common stock of Sinclair, and he had utilized some of his holdings to fund a GRAT that he had established for the benefit of his children. After establishing the GRAT and using his holdings in Sinclair, Smith, pursuant to the language of the GRAT, used his power of substitution to reacquire the Sinclair shares. And then, within 6 months of that reacquisition, sold the shares on the open market, which in turn triggered potential liability under Section 16B of the Securities Exchange Act of 1934. And that's what we refer to as the short swing statute. And it's a strict liability statute, Brian, that imposes strict liability on corporate insiders whose purchases and sales result in what we call short swing profits, and compels them to disgorge such profits if they earn them after a purchase or sale within 6 months of each other. Because it is strict liability, there is no need to show misuse of inside information or any other unlawful intent for there to be a successful claim stated under the statute.
So Jim, how did the court rule in this case, and what can we take away or learn from this?
Sure. Interestingly enough, the ultimate ruling and the ultimate language used by the court was to find that what occurred here actually fell within the four corners of the statute, and that was the purchase, the reacquisition, and then sale within 6 months, which under the law is prohibited primarily to attempt to avoid the unfair use of information by insiders who may be in an informationally advantageous position. And the court held that Smith's exchanges of property of equivalent value qualified as a purchase under Section 16B. And that was important because Smith had been arguing to the contrary. Also, the transactions involved this equivalent amount of assets such that the values equated to what was in essence the fair market value in the open market. Thus, the court concluded that Smith's acquisition of stock from the Grats were purchases pursuant to 16B.
Okay.
Smith had argued that treating such a reacquisition as a purchase was unnecessary because it was highly unlikely that that type of structure and reacquisition from a Grat would in fact result in a purchase. And he also argued that due to this structure, there was no informational advantage for him over the beneficiaries of the Grat or over the trustees of the Grat. The court, however, was not convinced because there was language in the Grat, getting back to what Katie said about how it was structured. And the court took a very close look at the language of the Grat and ultimately determined that the control over the investment decisions was vested in the trustees and not in Smith. Therefore, while he did have a power of substitution pursuant to the Grat, he did not have authority or control over investment decisions, such that the court ruled that the reacquisition was in fact a purchase because it was a change in beneficial ownership.
Well, thank you both. I want to thank you both for your time and certainly your expertise today on a longer court case, but you managed to do it pretty quickly and summarize it well. And I want to thank all of you for watching our presentation. For more information, please visit us at foley.com under Family Offices.